Hi, everyone, and welcome to this week's episode of our live webinar series, proudly presented by immigrationquestion.com, powered by My Legal Software, your trusted platform for real time immigration answers, attorney insights, and empowering legal education. My name is Anisya Mukherjee, and I'll be your host for today's webinar, Criminalization of Employment. Are visa holders at risk of removal? For millions of people in the US on temporary visas, students, skilled workers, interns, employment isn't a luxury. It's a necessity. It's how they support themselves, pay tuition, send money home, and build a career. But what happens when immigration authorities view that employment as unauthorized? Could a simple job or side hustle actually put someone on the path to deportation? That's what we're unpacking today. Because in 2025, the stakes are higher than ever. The rules around employment and visa status are shifting, and violations, even accidental ones, can lead to serious consequences, including removal proceedings. We are thrilled to be joined by attorney Sonu Lal, managing attorney at Gary and Associates and a powerhouse in the field of business immigration. With over 15 years of experience, attorney Lal has helped thousands of clients navigate complex visa issues including H-1B, E-1, E-2 adjustment of status, employer compliance. He's admitted to practice in New York and before federal courts. He is widely recognized for his strategic thinking and deep expertise in enforcement trends. Attorney Lal, thank you so much for joining us again today. It's always a pleasure to have you on the show.
Thanks for having me.
Before we get started, just a quick reminder. Immigration Question is a platform that connects users to licensed immigration attorneys. We are not a law firm, nor are we affiliated with AILA or USCIS. All legal services are provided independently by attorneys registered on our network. So let's jump right into it. Attorney Lal, we're hearing a lot about the term unauthorized employment lately, especially in the context of F1 and H1B visa holders. Can you explain what counts as unauthorized employment under US immigration law?
So, before I answer that question, let me give a context about today's topic and whether work visa holders are at risk of removal. Recently, government issued a new policy about NTA, notice to appear. Notice to appear means if you are not maintaining a proper status in the US government can issue this document called NTA, which essentially means they are initiating removal or deportation proceedings against you. So I'll give you an example. Let's say you are working on an H-1B visa. You file for your extension of H-1B visa. For some reason, it gets denied. So what will happen? Government will immediately issue the NTA, notice to appear, which means they will start the removal proceedings against you. Before this policy, that was not the rule. And this NTA policy is not something new. Even the previous Trump administration uh, started this policy, but then when the government changed, the Biden administration ended this policy. Now again, with the new Trump administration, they're starting this policy. And very recently, I've seen few cases where the H-1B visa got denied, and the government immediately issued the NTA. In other context, let's say by mistake you are on dependent visa such as L2 or H4, and for any reason, by your mistake or by mistake on the side of USCIS, your extension request gets denied. The government will immediately issue you the NTA, start the removal proceedings. It's kind of very scary for people who receive those documents or those NTAs from the government. If you unfortunately receive the document, immediately contact an attorney. And to avoid receiving such documents, make sure your change of request or your extension request are being filed on time and properly. Now, about the question that you asked, what is unauthorized employment? So, unauthorized employment means if you are not authorized to work in the sorry in the US and you work, that is unauthorized employment. Second scenario is You are authorized to work, but until a limited period of time. And then you continue your employment even after that date. That is also unauthorized employment. For both the reasons, government can cancel your visa, issue the NTAs.
Right, thank you for that breakdown. Now, it seems like the consequences of even unintentional violations are getting more serious. Are you seeing increased scrutiny or enforcement from USCIS or ICE when it comes to employment violations?
Yes, our office is seeing increased scrutiny across the board. For example, uh, people who have criminal record, any kind of criminal record, and they are maybe on work visas, or maybe even they are green card holder and they had a criminal conviction many years ago. ICE is arresting them, detaining them, and initiating removal proceedings against them. In terms of H-1Bs, we have seen increased FDNS site inspections, and for F1s, we have seen increase in the RFE when people are applying for uh, EADs or STEM EADs, and if they had any kind of law enforcement interaction, even receiving a traffic ticket, even then we are seeing increased number of RFEs.
Now, let's talk about students for a moment. A lot of F1 holders take internships or engage in side gigs without realizing the risk. What do they need to know about OPT, CPT, and what qualifies as compliant work?
Well, these students need to understand meaning of OPT. It's optional practical training. Even though the work authorization they get is unrestricted, but under the regulations, the training, the job should match with their educational qualification or whatever degree they took it from the school. For example, if someone did an accounting degree, just an example, and they are working for an uh, employer in some IT related job, or vice versa, if somebody got a degree in software engineering and they are working in some kind of business management related, even though the OPT is unrestricted, but that does not match with their degree. So in that case, they are violating their status if they are not doing the job as matching with their degree. So they should keep in mind. And I've seen a few students, if they cannot find a job since they have an EAD, they are working with DoorDash, they are working with Uber. It has nothing to do with their education that they have received in the US. And in that sense, they are violating their status. They're inviting trouble in those cases. So keep in mind what kind of job you are doing if you are working pursuant to F1 OPT or STEM OPT.
Okay. Um, that brings me to workers and entrepreneurs. For H1B or E2 visa holders, how much flexibility is there when it comes to side projects, contract gigs, or changing employers?
So both kind of visas has a lot of restrictions. But the good news is with H1B, the regulations have changed recently in January 2025. And with that, even if you are on H1B, you can, in a sense, you can self-sponsor yourself and do your own business. And this is how it works. Let's say you are on H1B, but you want to own and operate your own business. But since H1B doesn't allow that, with the new regulation, what you can do is you can form your own company as a 100% owner, or maybe a majority owner, or a minority owner. And let's say you are 100% owner, you formed an LLC. That company can sponsor you for an H1B visa. You will not have to go through H1B cap again in the lottery since you are already on H1B. This your company can file initially at least can file a concurrent part-time H1B. The initial H1B will be for 18 months, and once your business is operationalized, you can file another extension. It can be full time. You can leave your current job, do full time. The first extension will be for 18 months. And after that, if you continue the business, then again you can have a 3-year regular extension. But essentially, the new rule allows you to have your own company even though you are on H-1B visas. In the context of E2, normally if you are on E2 visa, you can work only for that company that you have formed through your investment, even though the spouse gets an unrestricted employment authorization document. If you want to uh, operate another business, I would say you can either do an amendment to your E2 visa with USCIS or structure the business in a way that your current business kind of operates that business. It's very, very technical, but if you are looking through those options, you should be talking to an attorney, specifically attorney who does a lot of these investment-based either E2 visas.
Okay, thank you. So, for example, say someone is contacted by the immigration enforcement or flagged for unauthorized work. What should they do first? What rights do they have in that situation?
So first of all, I would point out that they have right to have an attorney present when these officers ask them questions. That's the first thing. So if you receive any kind of such notices from immigration, please consult with an attorney, retain an attorney. Attorney can guide you how to resolve that issue. An attorney can be present when the immigration asks you all these questions. An attorney can further provide you guidance how to deal with that situation.
To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. You can ask your immigration questions for free in any language and get connected with the licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And in some exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. Attorney Lal, as an immigration attorney who also uses our case management software, which is powered by My Legal software, what would you say is your favorite feature, and how has it impacted the way you manage your cases or serve your clients?
So over the course of my career, I've used numerous softwares related to immigration. And most of the softwares, they either work for attorneys who work on business immigration cases, such as H-1B, POM, I-140s, or they work only for attorneys who do the court work. But this is a unique software. It works for both kind of practices. And I practice both. I practice business immigration. I do removal defense also. And this software, it's good with the forms where the business immigration practitioner use a lot of forms, spend a lot of their time on forms, immigration forms. It works for people like me who also do removal defense, like uploading a lot of documentation, creating events, keeping track of court dates. So that combined feature where, as a practitioner of business immigration as well as removal defense, it has features of both kind of practices, which I have not seen in other software providers. So that's a great feature of this software.
Thank you so much for that. So before we dive into our live Q&A session, let's look at broader trends. What are some of the latest developments in 2025 regarding how the government is treating employment violation amongst visa holders? Should people be more cautious this year compared to the past?
Well, definitely, answer is yes. Overall, what we are seeing is increased scrutiny. Let's say government has already increased scrutiny for people who are applying for F1. Anybody who's applying for F1, they have to make their social media profile public. That's one part of it. For H1Bs, we are now started increasing RFE rates. Since past 4 years, we hardly see any RFEs. Now we have seen those have increased. You have seen increase in the FDNS H-1B site inspections. Also, with all that, what the side effect is, every other filing, either employment-based or family-based immigration petition, the processing time is just increasing day by day. So normally at this time, I-140 petition filed in regular processing taking almost 15 months, 17 months, which is a lot.
Thank you. Now we'll dive into our live Q&A session. So this is your chance to ask Attorney Lal your own questions directly. Just type them in the chat or call us live at 516-703-3483. Our first question is, I got arrested but the charges were dropped. Will this still affect my visa or green card?
And this is a great question, a very timely question because we are seeing this scenario a lot. So depending upon what kind of visa you have, if you were arrested, charges were dropped, let's say you are on F1. In those cases, ICE in recent weeks deactivated the service, and again after lawsuits were filed, activated. So a lot of drama, a lot of things happened. But most typically, if you are on H1B, even if the charges were dropped, expect an RFE next time when the employer is going to file your H1B. And this weird RFE, the RFE would say something like that: you have to come for a biometrics appointment, and then USCIS will send you a biometrics appointment. You will go there, you will give your fingerprints. And recently we were getting question, what if I go there and I get arrested? No such thing happens so far. American Immigration Law Association also reported that no such thing happened, and people can go for their biometrics appointment. And in response to that RFE, they can provide the proof that they appeared for their biometrics appointment. But that's about the H-1B visa. With respect to green card holders, if the charges were dropped, it should not be a problem. But if you were convicted for a crime, even though it was years ago, chances are ICE might reopen it, might start a removal proceeding against you. And keep in mind, if you think you are eligible for citizenship at this time, you should file for it as soon as possible.
Thank you. Next question that we have from the audience is, they stopped me at the store for a mistaken payment. The police were called, but I didn't go to jail. Is that a problem for my visa?
As I said, if you were arrested, you were taken to a police station, which means law enforcement created a criminal record for you. If you are on F1, chances your F1 visa might get cancelled. If you are on H1, chances you might get an RFE next time when your employer file H1B amendment or extension.
Okay. Thank you. Next question we have is, I was caught driving without a license. I am on a student visa. Will this cancel my status?
It happened with so many people when they caught in such circumstances. At least ICE deactivated their service. In such cases, Department of State might cancel their visa also. So if you are in such a situation, either you will have to leave the US, apply for visa, come back again, or you can apply for what is called F1 reinstatement. In that case, if the your service has been deactivated, you might reach out to a school or a different school, get new I-20, and apply for reinstatement with USCIS.
Our next question is, I have a criminal record in my home country from many years ago. Is that a problem for asylum or green card?
It depends upon what kind of criminal record you have. If it is a serious offense, yes, it can be a problem for your asylum as well as for your green card application.
All right. Thank you. Next question. I am a DACA recipient. The police arrested me for something small, not a real crime. Will they stop my work permit now?
It would actually depend upon for what the arrest was. If somebody says it's a small, not a real crime, it all depends what are they charging you with. So if you have been arrested, I would advise consult with an immigration attorney who does criminal and immigration. They can look at the record and provide you proper guidance what kind of consequences you're facing at this time.
Okay, thank you. Next question is, I already got a visa, but now the US Embassy canceled it because I was arrested. How can I come back again?
So if you got arrested, you probably would want to hire a criminal attorney, see if the charges can be expunged or dismissed. And then what you can do is you can reapply for that visa and see if the consulate can issue you the visa after the charges are dismissed.
Okay, thank you. And then this is going to be our last question, which is, I have a 10-year green card. Suddenly, I got a mail from ICE. They said I have to go to court because of my old case. Why now?
It's hard to say why why you're getting a mail from ICE since you already have a 10-year green card. It may be that you have some kind of criminal conviction. That's what I can think of. Because in such cases, we are seeing even green card holders are being detained if they had any kind of criminal conviction, not just arrest, criminal, they were convicted of a crime. So if you have such a situation, then you should need you need to consult with an immigration attorney who can help you with that.
Thank you. That was our last question. So that was a great way to end the show. Thank you so much for joining us, and a special thank you always to Attorney Lal. It's always a pleasure to have you here.
Thanks for having me.
Thank you. We hope this webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our site to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Wednesday for another enlightening edition regarding another burning immigration topic. Trust us, you won't want to miss it. Once again, thank you, Attorney Lal. We look forward to having you back soon.
Thank you. Thank you. Bye.
Thank you.